Good evening, everyone, and thanks for coming to the Sixth Circuit Court Candidate Forum. My name is John Langlois, and I'm blessed to serve as the Executive Director of Dads and Moms of Michigan. DMM is a nonprofit that helps children by bettering their lives, and helping them be part of both their parents. We're education and support services. The purpose of this debate is to provide the ability for everybody to know who the candidates are so they can make an educated decision. More information on Dads and Moms of Michigan can be found at www.dadsandmomsofmichigan.org, and yes, we know that's a mouthful. Our candidates, McDonald and Frye, are vying for the seat being vacated by retiring Circuit Court Judge Edward Sosnick. State law mandates that he retire due to his age. Tonight's event is a round-robin candidate forum. There will be 10 predetermined questions. Each candidate will have 5 minutes to respond to each question. Our moderator tonight is Mr. Frye from the Oakland Press. I'd like to thank him for being here. And with that, I'd like to turn the floor over to Mr. Frye so we can get started. We're going to do a coin flip. Mr. Frye, the floor is yours.
Thank you. Oh, I'm sorry. Would you like to call it, please?
Heads.
Tails.
Dan goes first, correct?
Yes.
That's exactly what I want to have.
Okay. I will start with the introductions. Dan Christ is a principal in the Bloomfield Hills, Michigan law firm, Hafley, Starrin, Hallahan, and Christ, PC. He's a lifelong Oakland County resident. He graduated from Brother Rice High School, was a 4-year letterman, 2-year captain of the Michigan State varsity lacrosse team, and graduated from Michigan State University with a Bachelor of Arts in 1987. He received his Juris Doctorate from the University of Detroit in 1991. He has a general practice specializing in municipal law and prosecutions, land use and zoning, construction, business, and general civil litigation. He is the city attorney for the cities of Ferndale and Lake Angeles and special counsel for the city of Ypsilanti. He has previously served as legal counsel to the Charter Township of West Bloomfield and city of Birmingham. He also provides legal counsel to the city of Rochester Hills and the village of Franklin, and with his firm has provided special counsel to other cities, villages, townships throughout the state of Michigan. He's a member of the Oakland County Bar Association's Municipal Law Committee, a past president of the Michigan Council of School Attorneys, and a member of the Public Corporation and Real Property Law sections of the State Bar of Michigan. He is a member of the Fraternal Order of Police, South Oakland Chapter. He has lectured and written on general law school matters, zoning and land use in Michigan, as well as the Michigan Freedom of Information Act and the Michigan Open Meetings Act. For more than 20 years, Dan has represented individuals, families, businesses, cities, and townships, providing legal counsel and advice to help people resolve their problems. He has litigated civil and criminal cases and practiced in state and federal courts and appeared before administrative agencies and tribunals throughout the state. Karen McDonald is an experienced litigator and advocate for families and children who will bring nearly 20 years of professional experience to the bench. She is married with 2 children and 3 stepchildren and resides in Birmingham, Michigan. Her professional passion has always been children and their families. Her education includes a BA in English from Alma College and JD from Wayne State University, where she graduated cum laude and was a law review editor. Her career began as a high school English teacher, but quickly she realized real passion lay in the law. Her law career began as a research attorney for the Court of Appeals. In 1999, she joined the Oakland County Prosecutor's Office, where she prosecuted felony cases, child sexual assault cases, and juvenile matters. She attained a 100% jury trial conviction rate. After a short stint at Bodman LLP as a general commercial litigation associate in 2004, she began a career as a family law attorney at Jaffe, where she remains as an equity partner. She has focused her practice on family law, but has also handled general civil matters and the occasional criminal matter. A committed community volunteer, Karen has served as board member for Starfish, a nonprofit organization that helps underprivileged children and their families in southwest Wayne County. Now for the questions. I'm going to start with you, Mr. Christ. You each answer the same question. Please tell us about the circuit court, about its purpose and its organization.
Well, thank you, Steve, and thank you, John, for affording Karen and myself this opportunity to talk to you this evening. It's a great opportunity to tell you a little bit about our background, our collective experience, and why each of us wish to replace Judge Sosnick on the Oakland County Circuit Court bench. With respect to your question, the Circuit Court is a trial court in the state of Michigan and handles matters of the criminal nature over a one-year misdemeanor and all felony matters, and handles civil matters where the jurisdictional amount exceeds $25,000. There is 17 current circuit court judges in Oakland County, and there is also a family division which consists of judges assigned from the circuit court as well as judges assigned from the probate court of Oakland County to attend to family matters, custody issues, paternity issues, and those can be, as I said, circuit court judges or could be probate court assignments.
It's in many ways a factual question, but go ahead and offer it.
It is, I'm not going to repeat his factual, I don't dispute that. But I do want to address, or maybe highlight one thing is that the Honorable Edward Sosnick is a family court judge. And many people in this room and many in the legal community and all of the circuit court judges know that that seat is a family court seat. And absent a strange, unusual act where there's a lineup of general jurisdiction judges that want to be family court judges, and we know there are not, because actually there are family court judges who are waiting to be on the general docket, it will be a family court seat. The family court is one of the most critical courts, in my view, facing this county. In that court, we have the ability as a county and as a judge to impact children. We will impact them through divorce and custody proceedings, whether that child comes in contact with the court because their parents are getting divorced, neglect and abuse issues where we may have to remove children from homes, and juvenile delinquent matters. This court, in my view, is one of the most important and significant courts in the county because we have the ability to affect change. And I see that every day because this is where I practice. And every Wednesday morning, you know where to find me. I am sitting in the family court because it's motion day, and I handle divorce and custody proceedings every single day. I've handled hundreds of these cases, and I'm here not because I want to, continue some political professional goal, but because I feel so strongly about that court and what it does and how much impact it can have. And for 15 plus years I've been an advocate and I've enjoyed every minute of it, but what I really want to do is be in a position where I can affect change and do the right thing and do what's in the best interest of kids, and I think the family court in Oakland County is the way to do that.
We're taking turns, so it'll be your turn next. And you very appropriately transitioned into the next question, which was, why do you want to be a circuit court judge? So that was, some of your answer was already stated.
I have to say I was thinking about this today, and I'm not one of those lawyers who has had a lifelong dream to be a judge. But the opportunity presented itself, and I thought long and hard about it, and it was a wonderful opportunity for me to do what I really think is so important, which is to have an impact on kids and families. But driving here today, I was thinking, it wasn't a lifelong dream of mine, but if you look at my life, both professionally and personally, I've been preparing for this job for my entire life. I was preparing for it when I started teaching public school and dealt with adolescents and high school students for 3 years. I was preparing for it when I was an assistant prosecutor and I was defending children who've been victims of child sexual assault. When I was saying to that 10-year-old little girl in the hall, I believe you. I know your mom didn't. I know your dad didn't. I know a lot of people don't, but I believe you, and I'm going to fight for you, and I'm going to try try to prosecute the person who hurt you. I was preparing for it when I went to Bodman and handled complex civil litigation, commercial litigation matters. And more importantly, I've been preparing for it for the past 8 years. I've been preparing in my 12-day trial in Wayne County where I represented the mother of a little girl who was sexually abused by her father, and we're seeking to terminate his parental rights. And moments ago, when I was on the phone with one of my clients on the way here, who's in the middle of the trial that I'm doing in Oakland County Circuit Court and Family Court, who I represented in a divorce matter and agreed to a joint custody situation, but candidly, mom just couldn't. She was not stable, and so we've had to start a proceeding and continue that to gain full physical and legal custody. I prepare for it every minute of every day. And lastly, I've been preparing for it personally. I'm a divorced parent. I'm proud to say my daughter's in the room tonight, my stepdaughter's in the room tonight, sitting next to my husband, and I'm remarried, and I have a blended family. And what I hold most important in my life is the relationship that I have with my children's father and the relationship I have with my stepkids. And I treat those relationships with respect and dignity because what I care most about are my children. And so I've been preparing for this job, though it wasn't my lifelong dream, for my entire life.
Mr. Chris?
Well, Steve, I've been an attorney in Oakland County for over 20 years, and I've handled a number of different types of cases. Civil litigation cases, criminal prosecution cases, helping individuals, businesses, cities help resolve disputes, help bring a resolution of matters where there's a conflict. And for over 20 years, I've seen what makes a good judge and what makes judges who are not as good. And really, it is critically important to have judges who understand that the courtroom is the people's courtroom, and that they're there, people, litigants, parties are there because they're seeking assistance from the judiciary in resolving disputes. And I understand that commitment to public service. I have the perspective, given my experience and breadth of my practice, to, I believe, provide important perspective and relief to those people who are helping and coming to the court seeking a decision. I have the appropriate work ethic. I have the 20 years of experience of treating people with dignity and civility across the bench, across the aisle, and recognizing that while you may disagree with respect to a legal issue or position, you don't have to be disagreeable. And I believe that integrity, that hard work is something that I can bring to the bench, which will be an asset to the people of Oakland County. Just briefly, Karen indicated this may be a family division assignment, and if it is, I understand that those decisions that family judges need to decide are some of the most important decisions that any judge can make. Making decisions with respect to custody issues, parenting time, are amongst the most important decisions that any judge makes in this circuit court. Well, I don't know. I have no insight with respect to whether it's going to be a traditional circuit court seat or a family division seat. I will bring my hard work, my integrity, and my impartiality with respect to cases that come before me to the bench every day if I have the support of the citizens of this county.
Thank you both. And this one, back to you, Mr. President. And you, as did she, you've kind of moved into the next
We're
question.
anticipating you, Steve.
Yes.
Is that what you're saying?
What would you bring to the bench, your background?
Well, this one might be quicker, but I did touch on that. What I believe I will bring to the bench is what I have brought to my cases over the last 20 years, which is a hard work ethic to fully and comprehensively understand the legal issue that may be before or which needs to be resolved by the court, to thoroughly research the law, understand the nuance of the particular case, and bring that insight, that intellect to the bench. So in addition to being a hard worker, I understand that parties that are before the court are looking for resolution. They're not simply interested in coming to court on Wednesdays. They wish for courts and judges to make decisions to help them move on with their lives. And so I'm committed to trying to be as efficient as possible with respect to the cases that might come before me, to make sure that I am prepared, make sure that the parties that are before me are prepared, so that decisions and the right decisions can be made so that these people can have closure and move on with their life.
Thank you. And the same for you?
If I'm elected, I will bring compassion, fairness, and experience to the bench. If you walked into my office today, what you would see is pictures of children, drawings, Christmas cards, school pictures posted on my bulletin board next to my computer. And they're not just my children. They are the children of my clients that I represent. And the reason that I have them is I have a very large group of clients who've remained connected and loyal to me, and many of them actually have worked on my campaign without being asked. And they don't do this because they're my close friends or because they feel like they have to. They do it because, and what they tell me, is that I guided them through a process, their divorce, their custody battle, their paternity issue, adoption, and I did it with compassion and intensity, dignity, and respect. I'm proud of those cards and pictures and letters that I get because it reminds me every day that I've dedicated my entire professional career to the field of law that, let's face it, a lot of lawyers won't cut through the 10-foot pole. You know, I'm going to respectfully disagree with my opponent. It's a family law seat, and it's going to be a family law seat, and it shouldn't be filled by a candidate that is waiting for it to be something else. What I know about divorce and these proceedings facing this court is that it's the most traumatic event in a client's life, in a person's life, and they'll remember how they were treated forever. There's someone that they'll remember more than their lawyer, though, and that's the judge. And you all know this, because many of you sitting in this audience have appeared before your family court judge, and many of you have walked away not happy. And it might be, their personal story might be one of 50 on the docket that day, but to them, it's the most important thing in their entire lives because it has to do with their kids and their personal life. And these people come before the family court to be heard. They want to know that they'll be treated with respect, and more importantly, they need to leave with the feeling that the judge who decided their case was fair and compassionate and really wanted to be there because they really feel passion and desire and have experience in the family court setting. And I want to be that person. I want to be the next Oakland County Circuit Court family judge. And I'm not waiting for it to be a different seat because this is what I've dedicated my whole life to.
Okay. We'll go back to you. Tell us about your experience trying cases specifically within the circuit court, whether within the criminal division, the civil, or the family court.
Thank you. I have tried, I don't know the exact number, but I tried felony cases in the prosecutor's office for 5 years that I was there. I'm proud to say I maintained a 100% jury conviction rate, and those were felony cases, many of which were capital cases facing life offenses. And so on the criminal side, I've represented just about all kind of prosecuted, and I've done some criminal defense work as well in private practice. On the civil side, I've handled trials and commercial litigation. I had the privilege to work at a very fine firm full of very smart lawyers who do a lot of different kinds of work and had a lot of exposure. And then more importantly, for the last 8 years, my emphasis has been on family law. I have represented clients in very, very complex and highly contentious custody battles. I represented clients in high net worth cases where you had to know a lot about business valuation, property contracts, and I've represented clients with paternity, adoption, personal protection orders, domestic violence. So if you look at the circuit court, whether it's a family seat or a general jurisdiction seat, as Dan thinks that it might be, if it's a pie, I have literally experienced and handled every type of case that either judge, no matter what court they're sitting on, would deal with.
Dan, Chris, tell us about your experience in trying cases within the circuit court, whether criminal, civil, or family.
Well, with respect to the civil side, I've handled cases that involve civil rights allegations, wrongful discharge cases, employment litigation, construction litigation cases, real estate issues associated with zoning disputes, cases involving religious land use challenges under federal law, cases involving environmental allegations under the both the federal Environmental Protection Act and the Michigan Environmental Protection Act. I've handled cases involving deed restriction cases. I've handled federal telecommunication cases in circuit court, issues associated with Open Meetings Act and Freedom of Information Act cases, which are statutory and are handled in circuit courts. And with respect to the criminal matters, most of the criminal cases that I've handled as a prosecutor have been at the district court level and have consisted of cases like domestic violence cases, where I prosecuted thousands of domestic violence cases, hundreds, perhaps thousands of drunk driving cases, assault and battery cases, fraud cases, just malicious destruction of property cases. So I try cases every year, both in state circuit court. I've handled cases in federal district court, Sixth Circuit Court of Appeals, and other state administrative agencies, including the Historic District Commission, the Tax Tribunal, the cases in front of the Michigan Board of Education. And so I have a broad experience with respect to a number of different types of civil litigation.
All right. And back to you, Mr. Christ. And because this race is separate from the other circuit race where you have the 5 incumbent judges being challenged by 2 challengers, this race is completely separate from that. In this case, you're replacing Judge Sosnick, who is currently on the family court bench, having earlier been a general assignment, judge. So we do have a couple of specific questions regarding the family court, because this is currently held by the family court side. ADEPT, which stands for After Divorce, Effective Parenting Together, is an educational and communication skills training program that serves the children of Oakland County by training parents to effectively co-parent. Co-parents learn to use appropriate communication rather than engaging in conflict and additional litigation, which has a detrimental effect on children. If assigned to the family bench, how do you plan on using this program? Do you have any other thoughts on how to help parents effectively co-parent? Mr. President?
Well, in addition to the SMILE program, I think it's critically important that, and I know Karen shares this, that the presumption is that both parents are in the best interest of a child with respect to that child's growth and being raised. And that to the extent that all other things are equal, the judge needs to be sensitive to that, and there really is a duty and responsibility of both parents to help in raising their children. So every available program to assist parents in trying to put aside their personal differences and recognize that the effort and attention to raising their child needs to be done every day and needs to be done cooperatively with their former spouse is critically important. And so I think that current programs need to be expanded with respect to that for education. And I think the judge needs to be mindful of circumstances where parties may play games with respect to post-judgment issues, and our family judges need to be very sensitive to that, and there needs to be enforcement of post-judgment issues where a particular party is violating a divorce judgment decree, and there needs to be a more prompt remedy for those parents that are needing assistance of the court and having that opportunity to continue to have a meaningful and important role in their children's lives.
Thank you very much. Karen Powell?
ADEPT is an example of one of the most effective ways we really can improve our family court. And the reason that it's an example of that is my personal belief and professional belief is that the single worst thing you can do for your child is to speak disparagingly about their parents, their other parent. MCL 722.23 factor J, the willingness and ability to facilitate and encourage the relationship with the other parent. It happens to be one of my, things I feel most strongly about in the family court. Parental alienation is a traumatic and awful thing that's going on. And judges need to be aware of it, they need to be educated about it, and they need to be prepared to enforce and have there be consequences to it. But a program like ADEPT really gives people, if they're willing, because they have to be willing, and educate them, because parents don't know. They don't realize how harmful it is to put a kid in the middle, to make the child be a messenger, to make disparaging comments about their parent. And programs like ADEPT are great ways for the family court to, in my view, lessen their workload, because it's 8 sessions of a very comprehensive program where people have to sit and listen and have to understand that if you want to help your child, there are certain things that you shouldn't do and you can't do. And I think I happen to be a very optimistic person, and I think most people, if they know that's harming their child, and they know if they are taught a different way to go about it, that they will. And so giving them programs like ADEPT is an opportunity. It's giving parents a toolbox so they have something to go to, because it's not sometimes instinctual. You're upset, you're hurt, you may feel like you didn't get a fair deal, you may feel economically like you didn't make out what you wanted to, you didn't get the parenting time you wanted to. But having a program where you can acknowledge what those feelings are and understand that despite what you feel personally, your job is to be a good parent and act in the best interest of your kids. And ADEPT is a program that says, here's how. So as a circuit court judge, as a family law judge, I would absolutely utilize those programs and hopefully more to come. I think it's a great model, and hopefully there will be more like it.
Thank you very much. Now, this next question deals with an issue that impacts really family court, whether it's within a divorce, within juveniles appearing for family court. This specific program is used by general assignment judges. I think mostly the adult treatment court. The adult treatment court offers the circuit court a sentencing alternative to nonviolent but felony offenders with serious substance abuse problems, whether it be drugs or alcohol. And the program focuses on addressing the underlying substance abuse problem that leads to the criminal behavior. Funding has been an issue for this program. How would you use this if you ended up with the availability of using it, either by someone before family court or as a general court? How would you use it? And is it worth improving the funding? Would you think it should be expanded? Is it worth keeping? Start with you, Karen McDonald.
My answer is absolutely yes. I've attended fundraisers on behalf and financially helped contribute to the adult treatment court. Feel very strongly about it. For those of you who don't know, it's an extremely intensive program. These participants are asked a lot of. There's a lot of demands on them to participate in this court. And what it's doing is trying to solve the problem rather than just push it away on somebody else. If you have a criminal defendant in front of you with a substance abuse problem, you know, you can sentence them to as many years in MDOC as you like. But if it's a substance abuse problem, eventually, as we know, they are going to be released. We have a serious problem with overcrowding, and you are putting them out on the street with no treatment and no tools and no ability to address the problem, which is their substance abuse problem. So I'm a big proponent of it. I hope that the funding continues. I'll be supporting it, whether I'm on the bench or not. That, like the mental health issues facing our the people of this county, if talk to a judge, talk to law enforcement, talk to lawyers. So many of the criminal defendants you see have substance abuse issues or mental health issues, and we can keep sentencing them to the max and try to make this a political issue. But the bottom line is, MDOC, our correctional facility, our jail, they are completely overcrowded and underfunded, and they do not have the capacity to just keep housing people and putting them in jail. That can't, for our community, be the answer. It's not sustainable. So the way that we do this, and every judge on the bench that I'm aware of, regardless of their political beliefs, they all, every single one of the circuit court judges in Oakland County are supporters of this court. And it's because they see what they see every day in their courtroom.
Well, I agree with Karen. I think in the appropriate circumstance, that type of program, alternative sentencing, makes sense. Obviously, you need to consider and evaluate the facts of a particular case. The court's principal job is to make sure to protect where a defendant is found guilty of the charge. You need to protect the community. But as Karen pointed out, getting to the root cause of the substance abuse issue not only is the right thing to do, but from a cost standpoint is the most effective utilization of resources. And government, all branches of government, need to be sensitive to that, to while protecting the public, try to be as cost-minded with respect to alternative sentencing opportunities and treatment as possible.
You, sir? I guess it's a little political now. Judicial activism is a term politicians like to throw around. If you see a case where there's a law that demands would hurt the child or potentially anyone in front of you, would you rule differently than the law mandated?
Well, it's an interesting question, but I think I view the oath of the judicial office to apply the law, and that is going to make for hard choices from time to time. There's invariably going to be cases where I would have a personal sympathy to a particular party or side to a controversy, where I wish to afford them relief if the law was up to me. But I think it's inconsistent with the oath of office to substitute my judgment for what the law requires. I believe that the judicial judge's role is to apply the particular facts of the case to the body of law that exists relative to that cause or controversy. And that just because Karen or I may have a black robe, it doesn't give us fiat to substitute our will for the collective will of our citizens elected representatives.
Okay, thank you. You?
I think, candidly, almost every order or ruling that comes out of the family court has a potential to hurt kids in some way. For example, the trial that I'm in the middle of right now, where I represent a dad trying to get full physical and legal custody, those children don't want to be away from their mom. They want to be with her. So any ruling on parenting time has the potential to hurt kids. That's not what they chose. If children get to choose, they want their parents to stay together, and so they don't have to choose between mom or dad, and they don't have to have two households. But the reality of it is that is what happens when two parents get divorced. And similarly, in cases of child abuse and neglect, those kids don't want to leave their mom and dad. And even in some cases where there's abuse and neglect, they still don't want to leave their mom and dad. And those are the tough calls that a family court judge needs to make. It's not so simple as I'll apply the facts of the case law to the body of law and the circumstances. This is a court of equity, and you have your statute. You have MCL 722.23, the best interest factors. But the bottom line is, these are close calls that every judge has to make, and it's not as easy and black and white as it is in a general civil criminal seat. But it's also probably a seat where you're called upon to make rulings every day, where it's not just against somebody's business interest. You do have really tough calls to make, and oftentimes they are calls that if you had the children in the courtroom, which we don't most cases, thankfully, they would say, I'm not sure I want that. No, I don't want that. But as a judge, you have to do what's in their best interest, not necessarily what you think they would prefer.
Nice to be with you, Karen McDonald. And you both touched on this a bit, but what would make you a better circuit judge than your opponent?
Well, I really like Dan. I think he's a very nice person, so I would never say anything bad about Dan. And I feel like the county's lucky, and I've said this since the beginning, to have such experienced candidates running for the seat, and I think Dan is a smart, great attorney. But I think that I would be a better candidate and would be a better choice for this seat because I practice family law every day. And it's not that somebody else couldn't learn it, but the chances are, if you haven't helped handle the divorce case or a child abuse and neglect case, and you haven't dealt with the PPO, a personal protection order, and you haven't dealt with a juvenile delinquent case in 20 years, you probably don't want to. And I think the citizens of this county need and deserve a candidate that has a desire and an experience and a shown desire to dedicate their professional life to the family court.
Sir?
Well, I also think that Karen would be a wonderful judge, and it's been a pleasure to have an opportunity to meet her through this exciting campaign. But I think really my experience, while not exclusive with respect to family law, provides an important perspective for the bench. If you look at the current family division judges, very few of them will have a family background. You look at Judge Alexander, who was recently a family division judge, or Judge Matthews, or Judge Gorsuch, or Judge Brennan, for that matter. They didn't have that family division experience. What's important is trial experience, and what is important is to have integrity, a commitment to treat each case impartially, to have the correct temperament, to listen carefully to the parties that come before you, to treat each party with dignity and civility, and then to make a decision. To make a decision, should it be a family division spot? As I indicated previously, those unquestionably are some of the most gut-wrenching decisions and the hardest decisions that judges in this circuit are called to make. The judges need to have compassion and empathy for the parties in those really tragic decisions that need to be made. Cases need to be resolved, but the judges have to have compassion in so ruling. I think that temperament that I have, the respect that I've had for my opponents over 20 years, and treating everybody humanely will make a significant difference on the bench, irrespective of where the particular assignment ultimately lands. And I believe that's why I'm the best candidate for the position.
Thank you, sir. This issue has come up with the United States Supreme Court recently about juvenile life offenses. In that case, that would be more of a general court assignment. But as a family court judge, you would get many juvenile offenders in front of you. prison sentence. Just a few years ago, the Oakland Press looked, and there were 40 people in prison from Oakland County who were 17 or younger, and I understand 17 is considered an adult, but in other areas of society, 17 is still a minor. And there were 40 serving life without parole sentences. The Supreme Court's ruled that that's now unconstitutional to be so young sentenced to life without parole. But saying that that's off the table, could you still sentence somebody, a young teenager, 14 or 15, to a lengthy adult sentence? Mr. President?
Well, Steve, I think it depends on the facts of the case, like it always does. And you would need to assess whether the sentencing guidelines provide a framework, but there's still ultimately discretion for a judge in sentencing that would need to be considered with respect to issues like any remorsefulness, whether there is a victim, so presumably there would, given your hypothetical. And you need to carefully evaluate that. So I'm not sure how, without more detail as it relates to your fact pattern, I would consider a sentence. But I think that as I indicated earlier, it is an important role for a judge in the context of a criminal case where a defendant has been found guilty, that the judge makes sure that the public is protected. And that might, again, depends on the facts, require incarceration. But as I also indicated earlier, it depends on the, to the extent that it's not a violent offense and there's alternatives where appropriate, those are things that I would consider.
I think the question is whether or not you think it's appropriate in that scenario to sentence a juvenile as an adult to life without parole. Is that your question?
But you can't now. In fact, it used to be mandatory.
Right.
And so now that's off the table. But could you sentence, if you were a general court judge, could you sentence a 14 or 15-year-old to a 20, 30, 40-year prison term? It would be murder, most likely, or something like that.
Right. Well, obviously, as the United States Supreme Court says it's unconstitutional, it doesn't really matter what I think. And I think that kind of goes to the core of what a judge does. Judges are not, we're not running so that we can make law, we're going to follow it. With regard to that fact scenario, I think in the very, very rarest of cases, it may be appropriate to sentence a juvenile as an adult. Oftentimes, if the prosecutor charges him that way, as a judge, you wouldn't have that discretion anyway. But it would definitely depend on the circumstances. I can't say never, because I think just as my professional career as a prosecutor, I have witnessed 14-year-olds do heinous, awful crimes to young children. And so I think it does depend on the case, but I think it would be the rarest of circumstances, because 14 is awfully young, and I think there's a reason the United States Supreme Court ruled it unconstitutional.
Number 10, Mr. McDonald. Please tell us your view on shared parenting. When and how should it be implemented? Under what circumstances, if any, would a shared parenting not be in the best interest of a child?
Well, it depends on what you mean when you say shared parenting. Shared parenting, in my view, is always appropriate. It depends on how much are you sharing. Are you talking about an equal parenting time schedule? I look to the statute, both as an advocate and absolutely as a judge. There are statutes, the MCL 722.23 guides us in determining custody and parenting time. And I do not have a view that sole physical custody should mostly go to mothers, or it should mostly be 50-50, or dad should get, this or that. And the reason I don't have a general rule about that is because of what I've seen and how I practice every day. I have cases where it makes no difference whatsoever if it's mom or dad, or it's who's been more involved in the child's life, who's equipped to be more involved in the child's life, and can they co-parent together? And of course, that's why we have programs like ADEPT, so they get better at co-parenting, so we can start with the presumption that everybody deserves equal parenting time. But I'm going to say this to, I think I say it a lot to my clients, and I think people forget, the family court does not make decisions based on what's fair to each parent. The family court's job is to make decisions based on what's in the best interest of children. And I know with the ADEPT program and what John's working on, educating parents about that, you might come in all day long and say that wasn't fair to me. You might be right. But the court's job is to determine what's in the best interest of children. So my belief or position on shared parenting is that it's probably one of the most important things and gifts you can give your kids if you do it well and you're a divorced parent. Because transitioning between two households, and it doesn't matter if you have 5 days or 7 days in a 2-week period of time, the biggest thing you can do for your kids is to do it with respect to their other parent and not speak disparagingly and not try to put them in the middle and make their lives as least traumatic as possible. So I think in most cases it works, but I would never say that I believe in every case it should be 50-50, because everyone sitting in this room knows that it really does depend on each case and going through the best interest factors.
You, sir?
Well, Steve, I think, as we stated earlier, I think both of us, the starting point is a presumption that the best interest of the child is to have a strong relationship with both parents. And that would be the goal, until you start looking at the particular facts of the particular case. And then you go through the statutory criteria of what constitutes the best interest. And you look to those issues in trying to assess in the event who should be the custodial parent, and then balance that on the issues associated with parenting time. But the starting point is, the way I would look at cases, gender blind with respect to a particular parent. Both parents would be coming in before me, until I've heard any facts of the case, with the presumption that both of them would and should have a significant role in the raising and upbringing of their children. And so that would be my philosophy with respect to a case coming in the door, and then taking a look at the specific facts and trying to figure out what the best interests are of the child. And obviously, if the child is of age, considering as one of the factors the preference that the particular child may have with respect to the custodial parent.
Okay. Thank you both. For those questions, I want to thank you both very much. Care to make a 1-minute statement? Conclude. We'll start with you and finish with you since you started. Is that okay?
Yes. I talked about this earlier about my reasons for wanting to be a circuit court judge and a family court judge. One of the things I think that's really important is the position that we are running for is available for only one reason. And it's because the Honorable Edward Sosnick is forced to retire. You can't run for judge after you reach the age of 70. And while it wasn't automatic, Judge Sosnick has endorsed one candidate in this race, and it's me. Judge Cheryl Matthews has endorsed one candidate, and that's me. Judge Lisa Gorska has endorsed one candidate, and it's me. These are all family court judges. And Judge Sosnick didn't automatically say, sure, I like you, I'll endorse you. He talked to me for a long time, and he considered both candidates. And the reason he's endorsing me to take the seat that, he has had such an esteemed career, is because he actually wants somebody in the family court with experience and a desire to really help families. Judge Sosnick will tell you that there are a lot of broken hearts he's leaving behind. And what he means by that is the people coming before the family court look to the court to solve problems that, candidly, we sometimes don't have the ability to solve. But what I will bring to that seat is a true compassion and and desire to really help families and children. I've been endorsed by the Detroit Free Press, the Oakland Press, the Detroit News, and these, I have a lot of endorsements, but the ones that mean the most to me are the endorsements that are not political. The circuit court isn't a place for politics. It is not a place to go to assert your political agenda as a conservative or a liberal. It's a place for a person who has a true desire and compassion to help children and families, and not a place to wait so that you can take a general seat. Dan's right. Nobody can tell you with 100% certainty what the seat will be and where it will end up. But I am the only candidate that, regardless of whether it is a family law seat, and I'll be honest, I'm running for this seat because it is a family law seat. I really want to be a family court judge. I have a great job. I wouldn't be taking a pay raise, I'd be taking a pay cut. I'm doing this because I care about the families and children of this county. And I'm proud of what I've done, and I hope that I'll be elected. And even if it is not a family law seat, and at some point it becomes a general jurisdiction seat, I have 5 years of prosecuting felony matters, not misdemeanors, felony matters in the circuit court. And I have 8 years of practicing general civil law and family law. And I believe that that is why I should be elected, and this county deserves that kind of candidate, and more importantly, a candidate that really wants to be a family court judge. Thank you.
Sir?
Well, Steve, again, I'd like to thank you for being a great moderator, and I'd like to thank John for organizing this event. Thank you, Karen, for participating tonight. I have not shouted out to my wife, Ann, who I've been married to for 20 years. I thank her for her patience throughout this long process. The sacrifices that she and my 3 children have made with respect to this journey have been significant and substantial, and I appreciate it. And the reason I have done this journey, have undertaken this journey, is because I believe that I have the appropriate experience, the important characteristic of integrity and temperament to serve as a circuit court judge. I've practiced for over 20 years, and I have a broad background of cases that I have handled, a variety of different issues, and I am passionate about serving people, and I believe that I can, in moving forward, can best serve the citizens of this county as a circuit court judge. And hopefully you will consider me for this position this November. I do have a website. I know Karen has a website too. If you're interested in getting more information about us, about our background, please check out both our websites and make an informed decision. Thank you very much for your time tonight.
Thank you.
I thank you both. You both did a fabulous job. Thank you very much.
Thank you.
Thank everybody for coming. The whole purpose of this was so we could make an informed decision. I think we'll be able to do that. I'd like to thank both candidates. We are truly, truly blessed to have 2 fine attorneys running to fill the seat. And no matter what happens, and no matter which one of these fine candidates wins, we're going to get a darn good judge. And we're truly blessed for that. So I thank you both. Drive safe, go Tigers, and all that other good stuff.
Thank you.